Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case. From your side of it, what is the importance of having a prenuptial and a postnuptial, and kind of what's the difference between the two?
So, depending upon the situation with the parties, prenuptial agreements and postnuptial agreements can be beneficial to both sides of the equation, meaning both spouses or future spouses, depending upon whether it's prenup or postnup. Chapter 4 of the Texas Family Code is the code that's promulgated to, for lack of better words, control prenuptial and postnuptial agreements. A prenuptial agreement can be used to state whether or not there's going to be any community property that would ever be created during marriage, whether or not the spouses are going to operate certain bank accounts and or investments as either separate and or community property. It allows you to control the destiny of your property beforehand, meaning before you get married. And then in a postnuptial agreement, maybe you've been married for 5 years and you decide it's time to do a postnuptial agreement, you can actually change the characterization of the property, and you can state that XYZ property is going to be spouse A's separate property, and ABC assets and debts are going to be spouse B's separate property, and then you can have a mixture of separate property and community property, just depending upon how you actually draft and get the terms of the either prenuptial or postnuptial agreement.
Yeah, I think that's good to kind of know this, because I think we all hear about prenuptials and the idea is like, if we get divorced, you get nothing, but you can kind of split on what is community and what's not community. Am I correct in what you're saying?
Sure, yes. You can, in prenuptial or postnuptial agreements, the agreement can be, and the terms can be whatever the two parties want to agree upon, so long as it's as it is within the confines of the Texas Family Code. You can't contract to pay or not pay or support a child or to not provide health insurance for a child or something of that nature. You're not allowed to do that. But for anything that deals with property and assets and debts, whether it be real property, royalty interest, whether oil and gas, whether it be investments, Bitcoin, it doesn't matter what it is. You can, as long as you can draft inside the parameters of Chapter 4 of the Family Code, you can agree to just about split up anything you want and characterize it as either separate and or community property, depending upon the agreement.
Is there any trends that you kind of see maybe recently around prenuptial, postnuptials?
I think the trend that I've been seeing is that not only do you execute a prenuptial agreement, but once you're married, you want to come back and also ratify that premarital agreement, meaning you have two parties who are not spouses who enter into a prenuptial agreement. Once you get married, I require that my client comes in with the spouse and the attorney, if the other spouse has an attorney, and ratify the actual premarital agreement to allow for them to say that they agree, they understand what they have entered into prior to marriage, and now that they're married, they're ratifying that agreement. So I've seen that trend a lot more now based upon some of the case law that's been occurring about what somebody would call challenging a prenuptial agreement.
All right. And that kind of leads into the legal framework we're going to talk about. So is there any key legal terms, principles, statutes governing prenuptials that I know you mentioned there, how there's some new case law coming about? Is there anything that a client looking to get a prenuptial, postnuptial might need to know about?
I would think that at the end of the day, I don't believe that a client prior to can read the family code and determine what Chapter 4 would say or what it means or case law. I think what somebody needs to do if they believe that they are in need of a premarital agreement or prenuptial agreement, if you will, or a postmarital or postnuptial agreement, that they should contact an attorney like Turner Monahan to discuss all the options and get an explanation of why they may or may not want to actually have a premarital or postmarital agreement.
Mm-hmm. Looking at just like the time frame, when we say prenuptial, that just means before wedding, like getting married, and post is after getting married, but before divorce.
Correct.
Okay. And so I know we talked about like combining the assets and things like that and choosing what's together, what's individual property. So is there any specific income or assets that they should be thinking about when they're going and talking about having one of these agreements?
Well, in premarital and postmarital agreements, you're going to want to make sure, as I said, to discuss your options with an attorney prior to deciding exactly how you want to set up your agreement. But one of the things you have to understand, or that a client would have to understand, is how the family code or the state of Texas looks at any type of asset or debt when you're married. And it's all presumed to be community property unless proven otherwise, which means that the burden is on the party who's attempting to state that something is not community, but rather it's separate property. A premarital agreement is what allows one to say, this is the proof. See, we've entered into this agreement. We've already stated that we are going to have income that should have been or that would be presumed community. We are actually agreeing that it's not community. It is separate income. And any morphing or any type of transitioning from income into an asset, it remains separate property. So whether you're doing prenup or postnuptial agreement, you'll want to know how the state treats certain assets prior to entering into the agreement and how it should be treated after entering into the agreement.
Is there anything that cannot be entered in through prenuptial?
Like I said, children's issues as it relates to child support, supporting of a child. You can't contract to do illegal things, stuff like that. You can contract to do things that are within the confines of the Texas Family Code, and so long as they are not abhorrent or that they don't go against public policy, it's called.
How does debt like fall into that? So can they separate debt ahead of time? So if there's student loan debt, things like that, can that be all included into a prenuptial?
Sure, premarital agreements they should be done with not only assets but debt. So you can clarify what debts at the time you're getting married are whose debts, and they remain separate, and then categorize or characterize the nature of debt when you are married, meaning that if debt is taken in someone's name, regardless of what they intend, it is their debt, if that's what the premarital agreement and or postmarital agreement states.
How do we make sure that these are enforceable by the courts?
Well, the best way to make sure they're enforceable is to, number one, follow what Chapter 4 of the Family Code states, and also to read the most current case law to understand how cases are ruling on certain things, and making sure that you contact an attorney like Turner Monahan and our attorneys and our paralegals to assist you in making sure that your premarital agreement and or postmarital agreement is as enforceable as possible. There's no way for any attorney or person to predict what a judge would do later on down the road if the premarital and or postmarital agreement is challenged, but you want to try to set it out from the get-go as clear as possible and as loophole-less, if you will, to make sure that your premarital and or postmarital agreement is enforceable.
So kind of mentioning like challenging things like that, if one of the parties involved in the prenuptial has a significant change in their financial status, will that affect how the prenuptial is upheld in any way? Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to behind the case.
Once you enter into a premarital agreement, depending upon what the terms are of that premarital agreement, if it states that in that premarital agreement, it doesn't matter that any financial change to one part or the other, that has no bearing on what occurs in the future. If you stated from the outset in a postmarital or premarital agreement that any and all income that comes in to spouse A is all spouse A's for the rest of their life and during the time they're married, and all income that comes into spouse B is spouse B's separate property, wouldn't matter if spouse A got $1 trillion. It would be theirs, and spouse B would not get anything.
Is there a time and place where they can modify the prenuptial and postnuptial
Sure,
agreements?
people do modifications or codicils to premarital agreements, and usually it's done with some sort of one-off where you keep the premarital agreement or postmarital agreement in place, but you may make what's called a codicil, which is a small addition to it, supplementation that says for all matters, in relation to this premarital agreement, everything remains in full force and effect, except for we are going to agree that the house we bought in Florida is going to be community property. You could do that if you wanted to. It's not something I would recommend that clients do, but you can definitely do it if you want to.
That's what I was going to ask next. Like if somebody is already in an agreement, but all of a sudden they get like a large inheritance that wasn't accounted for, like what kind of happens there? Are they able to go back in and make changes for inheritance?
Well, inheritance is presumed to be, under the family code, inheritance is separate property. Okay. So whether you included that in the premarital agreement or not, it would be separate property. But then you could go in and you could add that if you wanted to, just to make it even that more explicit, that everybody understands that we've added a codicil and that the inheritance from the separate property is that person's separate property. But by law, by case law and under the family code, inheritance is by its very nature separate property unless proven otherwise, because it's a gift.
How are children or custody, is any of that set up ahead of time in prenuptial in that case, or can that even be touched in a prenuptial?
Rarely, and it's not something that I like to do in our premarital and postmarital agreements. You can set it up to a certain degree about who's going to pay for college and or who's going to pay for private schools and stuff, but conservatorship, possession and access, and child support is really not something that I would advise placing in a premarital agreement and or postmarital agreement.
So if death occurs, does that affect kind of anything after death with a prenuptial or postnuptial if they stayed married the whole time, but they had that agreement?
The death won't really matter. I mean, it's all going to go, and that's more of a probate question, but whatever the probate courts decide based upon what the premarital agreement says, that's what would happen. So once you pass, you're no longer married because you can't be married to a deceased person, but it would end up going through probate and you'd have the estate. So there could be issues with that, but that would be handled in probate. Fortunately, I don't do that.
Shifting a little bit to stakeholders, I know we've talked about children, parents, spouses, things like that, but is there anybody in like the spouse's life that this prenuptial can really have any effect on other than them individually?
Maybe from the perspective of if there's a death, but again, that would be handled in probate. But a premarital agreement, postmarital agreement can't be assigned to anybody because that other person, they have no contractual obligation. There's no bargain for exchange. It's only between the two parties that are in a contract together, because marriage is a contract. So those two people can contract however they'd like to during the time that they're married, or at least the Texas Family Code states that they can, along with case law in the Supreme Court. But it should not have any effect on any other people other than maybe what they inherit at some point in time. But again, that would go through the probate courts.
Is there any challenges a couple might face while drafting these agreements?
A lot of the challenges you have is for clients and persons to understand the language that you've put in there. These generally aren't short. Most of our premarital agreements are between 35 and 40 pages long, because we try to, while we hope for the best, we try to prepare for World War III. So, if a nuclear war doesn't happen inside of your marriage, which let's hope it doesn't, then having a good premarital agreement, postmarital agreement is probably something that may not even give rise to there being any issues, because everybody understands what they had. However, something does occur during the marriage and people start arguing and challenging it, you're going to have a much bigger problem on your hands. So you want to make sure that people understand what you're putting into them to understand what they're doing with their assets and their debts. That's what you have to do in premarital agreement or postmarital agreement.
Are there any specific cases that you've dealt with that you could share kind of what that looked like?
I mean, most of our cases that we deal with, one spouse or the other will contact us and they'll always say that they want to do this by agreement and the other person's ready to do it. We can't represent two people. We can draft a premarital agreement based upon the terms that are provided by our client. And to the best of our ability, we incorporate any and all of the terms that they have, so long as they don't violate public policy. And it's something that we believe that we can place into a premarital agreement and or postmarital agreement and get that agreement to where both parties can understand it. And a lot of times the other side, the other spouse, will have an attorney, and you'll go back and forth, maybe tweaking language here and there just to make sure it's perfect for the parties. That's really what we try to do, is try to figure out exactly what the parties are attempting to accomplish and allow them not to worry about the premarital or postmarital agreement and to move on with their married lives.
Yeah, definitely. At what point, so when should they really start considering making these plans for prenuptial and postnuptials?
Well, I mean, if somebody is prior to marriage, obviously, if you're thinking that you need to protect your assets and or the other side doesn't want to have any obligation to any of your debts, you would want to contact an attorney like Turner Monahan and allow us to provide you as much advice as we can to whether or not you should actually enter into a premarital agreement. And if you should, what the terms should be based upon the facts. Everything is the thumbprint. So it's very fact driven, and everybody's life is different. Everybody's investments and assets and debts and whatever it might be are different. So each case is a thumbprint. It's very rarely a cookie cutter agreement. There are a lot of agreements in the world that are cookie cutter. Premarital agreement, postmarital agreement is just not one of them.
Is there any common questions you've had from any clients around prenuptial, postnuptials?
Most of the questions I get is this going to be enforceable? And the same statement I give to everybody: if I could predict the future, then I'd probably be a billionaire sitting on the beach. Unfortunately, I can't. But what we can do is we can read the case law, we can look at the case law, and we can make sure that we attempt to draft the premarital agreement to the best of our ability for the terms that you and your spouse want to have, and at the same time, try to make sure that it's enforceable down the road and that there's no issues with it.
All right. And so how can somebody, if they're in the DFW area, contact you?
The easiest way to contact us is by phone, which is 817-332-4477, or for them to contact us through our website, which is tumolaw.com, TUMOLAW.com. And there's various ways on our website to be able to contact us. And if you send in an inquiry, we get back to most of our potential new clients very quickly.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com, that's TUMOLAW.com, or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.